Good afternoon, everyone. My name is Nguyen, and I have the pleasure to welcome you to today's event presented by the Museum of the Republic of Vietnam. I will serve as the moderator for today's event, and I will be joined by Quan Nguyen and Professor Lan Cao. Today's topic is U.S. Constitution and the Republic of Vietnam government. As many of you are aware, the fall of Saigon in April of 1975 resulted in a mass exodus from the Republic of Vietnam, also called South Vietnam. Before this, South Vietnam aspired to become a strong democratic country with many rights for its citizens. With assistance from the United States, South Vietnam was developing a government guided by a constitution similar to the Constitution of the United States. Professor Lan Cao will begin today's event with a discourse on the U.S. Constitution, and Quan Nguyen will follow with a short discussion of the Republic of Vietnam government and its establishment after Vietnam became independent from France through the First Republic and subsequent Second Republic. Before we start the presentation, I would like to ask everyone to be on mute so we can avoid the noise background. If you do have any question during the session, you can send them through the chat, or you can click on the hand icon at the bottom of the screen to indicate that you have a question. We will have a question answer session at the end of the presentation. I'd like to mention a little background on Quan Nguyen and Professor Lan Cao. Quan Nguyen is a director of the Museum of the Republic of Vietnam. The museum located in Westminster, California. He is also a medical doctor, a practicing physician, and a history student with special interest in the Vietnam War. Professor Lan Cao is a professor of law at the Chapman University Fowler School of Law and an internationally recognized expert specializing in international business and trade, international law, and development. She has taught at Brooklyn Law School, Duke University School of Law, University of Michigan Law School, and William Mary Law School. She's a writer, and she's the author of Monkey Bridge, The Lotus and the Storm, and Family in 6 Tones. So now, without further ado, I will hand it over to Professor Lan Cao.
Because, for example, Nazi Germany had democracy. Hitler was voted into power, and most of the legislation was approved. So unless you have a system that checks the majority, it can be very, very bad for the minority. And in the US, we have checks on the majority. So don't think that democracy is always whatever the people vote for will be okay. So that's the number one issue I want to bring up. The second issue is that I want to show you that the American constitutional system is designed, okay, first and foremost, to minimize concentrated power within the federal branches of government. So sometimes you will hear a lot about gridlock, okay, oh my God, we can't get anything done because Congress can't agree, the House can't agree with the Senate, and then the House and the Senate fight with the executive branch. For better or for worse, that is actually how the system was designed. It is not designed to make things go very fast. Because of course, if you have one dictator and you have one party only, everything will go very fast because only one person or one party decides. So the US constitutional system is not designed to be efficient. And the downside to that is that, oh my God, we have gridlock, okay? The answer to gridlock is not to say we want a strong man. who will just push everything through, because that would actually go against the very built-in safeguards that the founders who wrote the Constitution really made sure that that would not happen. They broke power up. Okay, so if you have to share power, you have to compromise. So let me show you how this is implemented in the US system. As I said, within the federal branches of government, power is supposed to be divided. So we have what we call allocation of power between or among three branches of the federal government: the executive, the legislative, and the judicial branch. On top of that, and I'll go into details about that in a minute, but on top of that, we also have limited power to the federal government. So within the federal government, you have separate power within the executive, legislative, and judicial, okay, branch. They're all co-equal. Not one branch is above the other. So they're horizontally equal in power. But if you compare the federal with the state government, there is also limited power for the federal government, and that's called federalism. So federalism means that the states actually have their own power that the federal government has no right to impinge upon. So it's not like if you're the president of the United States, you are ruling over the state of California or the state of Texas or the state of Connecticut. The states themselves have their own government. And in fact, the federal government is supposed to have restricted power. The power of the federal government is what we call enumerated power. The federal government only has power that is granted to it in an enumerated way, you know, like you have to, it's specified. And if the federal government's power is not enumerated in the Constitution, Congress does not have the power to impose anything beyond what it has been given explicitly or impliedly in the Constitution. Okay, so let's talk about, first of all, within the federal government system. So this is how I want to make sure you understand how my talk is going to go, right? We're going to talk about the separation of powers. Then we're going to talk about what rights do citizens have. So I'm going to talk a little bit about the Bill of Rights. And then I'm going to talk within the Bill of Rights specifically on the First Amendment, which is freedom of speech, freedom of religion, and then on immigration issues, like the Chinese Exclusion Act, so that you understand Congress's power over immigration, because I think that has a lot of impact on our community. And then the civil rights movement. Okay, so I'll try to compress all of that within my time. So let's talk about the federal government and separation of powers. Article 1 sets forth the power of what Congress can do. Article 2 sets forth power of the executive, that's the president. Article 3 is the power of the federal courts, okay? So as an example, Congress legislates. So it's the House and the Senate that come up with legislation. And then look at how checks and balances work. That's not enough for the founders. Once Congress come up with legislation in both houses, so they have to compromise already. So even Congress has divided power, okay, between the House and the Senate. The president then also has the power to veto the congressional legislation. If the president vetoes that legislation, it does not become law. Okay, so you need the interaction of the Congress and the executive branch. On top of that, however, if the president vetoes congressional legislation, Congress can also override that veto, but it takes a 2/3 supermajority vote of each of the houses for Congress to be able to override that veto. So you see all the checks and balances. There's checks and balances within Congress, because it's not just the House, it's not just the Senate, both of them have to compromise. And then they can be vetoed by the executive branch, which can then, the veto can be overridden back by Congress, okay? Very, very segmented power, because the founders were very worried about absolute power. Second way that American system divides up the power is this. The House is very majoritarian because the House actually, how many House representatives, Congress people, each state has actually depends on its population. So if you have a very, very dense state in terms of population, that state is going to have more representatives in the House of Representatives. So that's truly very, very much a reflection of democracy. Okay, if you look at the Senate, it is anti-democracy because every state has 2 senators. So even if you have Wyoming, which is a very, very sparsely populated state, or North Dakota, not a lot of people live there compared to Texas, New York, or California. Nonetheless, each of those states has 2 senators. That's anti-democracy. But it is meant to make sure that there is that check and balance again, because the founders did not want democracy to be unhampered. Okay, there's always a check against democracy. There's a lot of controversy now actually about whether or not that's fair, that the people of California have 2 senators, just like the people of Wyoming. So because we have so much political division now, this issue of whether or not every state gets 2 senators is actually fair. So that's something that you may want to think about, that it was uncontroversial at the time of the constitutional ratification, but it has become quite controversial now. Now, let's look at other ways that power is segmented. The president makes treaties, right? So the president is usually given primary power in foreign affairs, because you can see that that makes sense, right? Because you do not want foreign affairs to be conducted by 100 senators or by Congress, which is very unwieldy because there are many, many Congress people and 100 senators. So in foreign affairs, the founders wanted the United States to speak with one voice. So that one voice is represented logically in the executive branch. That's through the president. So when the president negotiates with foreign countries, the president is the one that initially negotiates with those foreign countries, and the president has the power to make the treaty. But the Senate has to give advice and consent to the president. So to have a treaty become a treaty, it needs 2/3 of the Senate to vote yes. So again, even in the area of foreign affairs, where the president actually has plenary power or primary power, there's a check. You need 2/3. So nowadays you will hear a lot actually about executive, like you'll hear the president issues an executive order. Think about that, okay? Because it's controversial, executive orders, because if the president feels, for example, oh my God, we cannot have immigration reform because the House doesn't agree with me and the Senate doesn't agree with me and the House doesn't even agree with the Senate, and we have a huge immigration mess. So the president says, I'm just gonna bypass all of Congress and I'm gonna issue an executive order. Is that legal? Is that constitutional? That has become much more of a common mechanism now because of the gridlock and because of the political divisions in the US. So you see very often the president, a new president comes in, issues executive orders, okay? Banning, let's say, Muslim immigration to the US, or banning in the 1800s, Chinese immigration to the US. Those have all been done historically. So when you see executive orders, you have to ask yourself, is that okay? Because if your only goal is my side gets the little prize that it wants now, then it's okay with you. Because, hey, I like this president and this president is getting the executive order out, great, it's my side. But if you think long-term, you may think that's damaging for the structure of the Constitution as envisioned by the founders. Now, let me tell you a little bit about the issue of power between the president and Congress. And this goes back to the issue of executive orders, okay? There has always historically been a tug of power between the executive branch and the congressional branch. So even before the extremely heated division that we have now in this country, this issue of the tug of war between Congress and the president has been existing in the US since its founding. So it's not a new phenomenon. So I'll give you an example of a very famous case, and then I would like you to think about this famous case whenever you see a president issue executive orders for whatever purpose, okay? So as I said, the US system is designed so that Congress makes the law and the president executes it. But sometimes the two branches overlap. And when you have overlap, it's going to be controversial, okay? Because if Congress, so where are the areas of overlap? Foreign affairs, okay? If the president enters into a treaty, but that's a foreign affair issue, but that treaty subject matter is something that the Constitution only gives to Congress, then you see that there is an overlap, okay? An overlap where the president has power over foreign affairs, but the president is exercising power in foreign affairs in an area that the Constitution also gave to Congress. Then there's going to be Congress going to say, wait, you're encroaching on my area. Okay, so here's a very famous case. By the way, the president in foreign affairs, the president is also the commander in chief, right? So there's a famous case called Youngstown. And this is during World War II. So Truman was the president after FDR, Franklin Delano Roosevelt died. And Truman took steel mills during the Korean War. So this is in the middle of a war, and there was a lot of need for steel. And the president did not want the US to be short on steel, which is needed to make guns and ammunition. And there was concern that the steel mill workers are going to strike, okay? And if they strike, that will make steel mill production be more limited. So Truman, on his own, seized the steel mills. Now remember, we also have the Fifth Amendment in the US, which means that the government, not like the Communist Party, can just go and take your private property, okay? Nonetheless, during wartime, Truman seized the steel mills to prevent a strike. However, Congress already had a law that was already in existence, which rejected the seizure of steel mills as the mechanisms for preventing strikes. So Congress already passed a law, and the president, by seizing the steel mills, now you have a confrontation between the president executive order and congressional legislation, which says no seizure of steel mills for the purpose of preventing a strike. The president said, well, I can take this action without relying on that statute, right? Because the statute says no steel mill seizures. The president has to execute that law. The president is not above the law in the United States. So if the president were to seize the steel mills, he has to have power from legislation. But he said, I'm using he because it's Truman. Hopefully someday we'll have a female president in the US, but for right now, I'm using he as a pronoun just because of historically that's been the case. So the president said, I'm not relying on statutory authorization. I have inherent powers. Right? So he's saying, I'm not relying on my power to execute the law through Congress. I have my inherent power. What's his inherent power? As commander-in-chief, or inherent power in foreign affairs. So interestingly, the case went all the way up to the Supreme Court. The Supreme Court rejected unilateral action by the president. The Supreme Court said, you may be commander-in-chief, but you cannot use this power to seize private property to prevent strikes, because the power lies with the lawmakers, Congress, not with you. Now, interestingly, the case is also very famous because the court came up with a diagram for determining when can the president issue something on his own or her own authority. Okay, so this is the diagram. if the president acts with congressional authorization, so if the president's action converges harmoniously with congressional legislation, the president's authority is at its peak. It's at the highest because there's no confrontation with Congress. Okay. If the president acts on his or her own in opposition to congressional legislation, that is at the smallest. You're at your smallest minimum power. It could still be constitutional, but it's gonna be really scrutinized because you don't want president to be a strong guy that's just gonna say, I'm gonna grab power, okay? If the president acts on his own authority, okay, not against Congress, not with Congress, but on his own, because there is inherent power granted to the president, then the power is uncertain. Okay, so that's what we call the Twilight Zone. So whenever the president acts on his own authority, so this is not a political issue, okay? This is not whether you're a Republican or a Democrat, because this issue will come up whether or not you have a Republican president or a Democratic president, because I'm only talking about the Constitution. And we all obey the Constitution because that's what gives this country its rule of law. So any president who acts on their own authority, you need to look at it and say, is this really constitutional? I would suggest don't look at it and say, do I agree with it? Because that's a very short-term view. Now, the president is commander-in-chief. Interestingly, the president is commander-in-chief, but under the Constitution, Congress is the only one that has the power to declare war. So, to what extent can the president pursue his or her commander-in-chief power and commit the armed forces of the United States to go to war without congressional legislation? So this is the controversy. During the war in Vietnam, Congress never declared war. And so they declared a Gulf of Tonkin resolution authorizing the US to take certain actions to defend against the Maddox against attack. But because Congress did not declare war, that became an issue for us as an ally of the US, okay? That's something we can talk about during the discussion if you're interested. Anyway, as a result of the controversy surrounding the war in Vietnam, Congress then passed the War Powers Resolution. So under the War Powers Resolution, which is legislation passed by Congress, okay, it says that the president, let's say in time of emergency, can commit US troops as commander-in-chief, send US troops, let's say to Haiti, okay, or to Panama. But the president is required by congressional legislation to consult and report to Congress 60 days after the commission of the troops. If not, Congress can override the president, right? That Congress can say, explain why you are deploying American troops. Okay, so I hope you see that in every single area of, I mean, I can go on about this, but I want to leave time for other issues. In every area of the federal government, for example, power is definitely segmented. Okay, within Congress, and between Congress and the executive branch. So now we talk about the courts. Okay, that's Article 3 leaves you the court, judicial, the federal courts. So if you are a Article 3 judge, you are a federal judge, and you have your position for life. So that means that unlike Congress, or unlike the president, who have to run for re-election or for election, if you are a federal judge, Article 3 judge, you're not running. So that means that, and this was on purpose, right? That means that federal judges are not pressured to be popular. They can make decisions that are unpopular based on their view of the constitutional position of the executive branch or of the legislative branch. So you can have a legislation passed by Congress and a federal judge can decree that that is unconstitutional. And the federal judge does not have to run for election, because when you run for election, you have to be kind of popular and people have to agree to vote for you. As a federal judge, you have that spot for life. So if you issue an order that is unpopular, nobody can remove you, okay? And you're not subject to re-election. Again, that shows you the federal courts are anti-majoritarian. It's not about democracy when you are a federal judge. And the founders understood that there are certain things that we want to insulate federal judges from. We do not want them to have to worry whether or not they're going to lose their job if they rule on something that is unpopular. Whereas Congress or the Senate, the senators and the House of Representatives, they can lose their job if they do something that the people don't like. Okay, so the federal courts are anti-majoritarian, even though they are in a democracy. The only way you can justify it is that the federal judges are appointed by the president, and the president is elected in a democracy, right? So there is democratic legitimacy because the judges are appointed by the president, who is elected, so you have democracy there. And the judges have to be approved by the Senate. So there is another layer of democratic legitimacy. But once the judge is in power, it's anti-majoritarian because they will strike out laws passed by Congress, which is democratically elected, and they can strike down executive orders by the president. Second issue regarding the federal judiciary is that it's very interesting. The federal courts exercise what we call the power of judicial review. So that case, there's a very famous case called Marbury versus Madison, which the Supreme Court says, yes, we may be a co-equal branch to the executive branch or to the legislative branch, but we are the ones that decide whether or not what they are doing is constitutional or not. Okay, so judicial review was established by this case, Marbury versus Madison. It's actually not in the Constitution itself. There's nothing in the constitutional text that says the federal courts have the power to strike down laws enacted by Congress. That was decided by the Supreme Court itself in Marbury versus Madison. So the federal courts decide that it has judicial review, but notice how the Constitution checks the federal courts. So very interesting. The Congress is the one that endows the court with jurisdiction. Okay, so Congress can decide, I'm removing jurisdiction from the federal courts. And the federal courts, even though they are appointed for life, and even though they can strike down acts of Congress, their jurisdiction is dependent on Congress. So for example, you may have heard in recent years that that Congress may decide we're not going to have 9 justices on the Supreme Court. We can have more than 9, right? If Congress decides we are going to create 13 seats for the Supreme Court, because now you have 9. And now, you know, if you want to play political games, now you have a Democratic president, a democratically controlled House, and 50-50 in the Senate, with the vice president being able to break a tie in the Senate. It is conceivable that the Democrats can pass a law that says we're going to expand the court to the Supreme Court to 13. 4 more seats, and then the president could fill those seats. It's not unconstitutional if the Democrats were to do that. Or if the Republicans were in power and they have that, they could do the same. Okay, so we call that packing the courts. You might have heard this. Congress can do it. Do they want to do it? They may not want to do it because they may not want you know, what's good for the goose is also good for the gander, right? So next election, it could be that the Republicans gain control and maybe the Republicans can do the same. And so in order to not do tit for tat, neither side may want to do it. But if they were to do it, it would be within their power because that's explicitly granted in the Constitution. Okay, so that ends my section on the issue of the allocation of power within the federal system. I want to talk a little bit now about the theme of limited power between Congress, let's say in the states, and then we're going to go and talk about the Bill of Rights. Okay. So as I mentioned, remember the federal government is divided within itself. Okay, that's a very important theme I want to relay to you. So I hope that you take away from this talk and understand, whether you agree with it or not, the US Constitution is designed to break up power. So you do not want a strong man president that jams everything through, whether that be a Democratic president or a Republican president. The system is designed to have not one party. You do not want it. You have one president who has unlimited power. That would be like having a communist party. Okay, so if you flee communism, you can be frustrated, but you have to understand that it is very dangerous to have power in any one party, any one system, any one person. And I think it is fantastic, speaking as a citizen, that this country has the foresight to break power up, even within the federal government, okay? So the federal government is divided between Congress. Congress is divided within itself, between the House and the Senate. Within that, you have the Senate being anti-democratic and the House being very democratic. So you see how there's just layers and layers of anti-majoritarian impulses, even within Congress. Then there is divided power between the president and Congress, and there's divided power between the courts and Congress, because Congress can remove jurisdiction and the court would not be able to decide on a certain case. Okay, now that's division of power within the federal government. How about the state and the federal government? So as I said, the federal government only has enumerated power. If the power that the federal government takes for itself is not enumerated in the Constitution, so we say if power is not delegated to the national government, it belongs to the states. Okay, so the states have the reservoir of power, and it is the states that decided when the Constitution was created and when it was ratified to decide what to grant to the federal government. So this is a very important principle. Power not delegated to the national government is retained by the states and the people. The federal government, the national government does not have general power, only enumerated power. More importantly here, there is no inherent legislative power that Congress has, okay? Congress legislates only pursuant to some enumerated power. There is no inherent power that Congress can say, as Congress, I have this inherent power. So basically for congressional legislation to be constitutional, it has to have a relationship to a specifically enumerated power in the Constitution. Or if it's not specifically enumerated, Congress has to be able to show reasonably that there is some implied power. So let me give you an example. Congress, Article 1 grants in an enumerated way to Congress the right to collect taxes. Okay. Congress has the right to borrow money. That's enumerated. Congress has the right to regulate commerce among the states, right? Because each state is its own government, right? So if the state of California wants to pass some commercial power within California, Congress cannot say, no, you cannot do that. But if California has legislation that maybe has an impact on Connecticut, in a negative way, okay, maybe then that would be an issue. So Congress has the right. Am I still on? Because something weird is happening. Can you still hear me?
Yes, you still on.
Yeah. Okay, so Congress has the right to regulate commerce. And there's this clause, it says Congress has the power to make all laws that are necessary and proper. So that necessary and proper clause has expanded congressional legislation, because Congress is going to say, well, it's not enumerated in the Constitution, what I'm about to do, but what I'm about to do is necessary and proper for carrying out the powers that are enumerated. So you gradually see an expansion of congressional power, and the Supreme Court has had to very often decide when Congress passes legislation, the legislation is not within the enumerated power. Is this legislation constitutional? Is it part of the necessary and proper power which Congress claims that it needs? So one example, and then I'll move on to the Bill of Rights, okay? One example is that in the 60s, Congress passed the civil rights legislation, which is to prohibit racial discrimination in public accommodations. So that means if you run an inn or a hotel or a motel, or you run a restaurant, right? That's a public accommodation. It's not your private house. Can Congress pass legislation that says you own an inn, that inn or that hotel is in California or in Virginia, and you don't want to serve minorities, mostly in the case at issue, you don't want to serve Blacks or African Americans. And Congress says, no, we're going to pass a new law called the Civil Rights Act, and you cannot discriminate on the basis of race. And the question became, is that constitutional? Does Congress have the power to pass that legislation? Because is it enumerated? Is this an enumerated power? And basically, there's a very famous case. There is a barbecue house. It's called Ollie's, O-L-L-I-E. Ollie's Barbecue House. It's a restaurant. And it turns out Ollie's Barbecue House, it's not an interstate restaurant. It's only in one state. It doesn't have franchises in other states. Does Congress have the power to regulate what it can or cannot do? And the Supreme Court found that Ollie's Barbecue Restaurant bought 46% of its food supplies through interstate commerce. So if it buys 46% of its food supplies through interstate commerce, then that leaves open the opening for Congress to say, we have the power to regulate commerce. So if you buy 46% of your food supplies through interstate commerce and you practice racial discrimination while you're doing it, right? Then restaurants practicing racial discrimination could sell less interstate goods and businesses would suffer. So Congress used its power to regulate commerce to pass the Civil Rights Act. Okay, so there are a lot more examples about whether or not when Congress passes a particular legislation, it's constitutional. Even the health care, what we call Obamacare, there's a question as to whether it's constitutional. And I can talk about that, whether or not that power that Congress used to say that, you know, we're going to pass this national health care as part of regulating commerce, is that constitutional? Okay, so whether you think it's great to have Obamacare or whether you think it's not great to have Obamacare, the question is not whether you agree with a legislation, it's whether or not that legislation is constitutional. Okay, because otherwise we're all going to manipulate the Constitution to get the result we want. And that would not really be what you want to do, especially me, who I have respect for the Constitution. So my question is it constitutional? Not necessarily whether or not I myself thinks it's a good idea. Okay. Now let's talk a little bit about the rights. So individual rights. Even though, as you can tell, there's a lot of structures built into the US Constitution to make sure that the government does not have so much power over citizens. Nonetheless, at the time of ratification, the states and the people within each individual states, the 13 colonies in the states, the Confederate states, they were very concerned about whether or not they're going to have individual rights. So as a condition to having the Constitution be ratified, the founders said that, okay, we're going to make sure that you really understand that we're going to make sure that the government doesn't have power over you in a way that would make the government be tyrannical. So we're going to pass the Bill of Rights. Okay, so the initial Bill of Rights, 10 amendments. Okay. So we don't have time, obviously, to talk about every amendment, but I want to make sure we understand a few important ones. The First Amendment. The First Amendment basically says Congress shall make no law abridging freedom of speech, freedom of the press, freedom of religion. Congress cannot prohibit the free exercise of religion, and Congress cannot establish a religion. So that means Congress cannot say, you know, we prefer Christians. So between Buddhists and Christian, we're going to make sure that we're going to pass legislation that is more preferential for the practice of and the worshiping of Christianities, and we're going to favor churches, and we're going to discriminate against temples. That's not allowed. Now notice that the First Amendment says Congress, so it doesn't bind the states because it didn't say state government. Okay, so it also doesn't say anything about private companies. So the First Amendment guarantees freedom of speech, press, and religion, meaning only that the federal government cannot take steps to restrain your exercise of the First Amendment. It was not until the 14th Amendment, which is after the Civil War, that the Bill of Rights became applicable to each individual states. Okay, so now I don't have time to tell you how that happened, but you can believe me that the Bill of Rights was not applicable to the state government until after the Civil War through the 14th Amendment. So now, whether it be state government or federal government, you have the right of free speech under the First Amendment, because the First Amendment is now applicable to the state government as well. But you do not have the right, if you are hired by a private employer, to say, well, the private employer, I have free speech rights vis-a-vis the private employer. You don't, because the private employer is not a state or a federal government. The other thing to make sure you also understand is that the US system with respect to the First Amendment is that the government is not allowed to restrict any expression based on content. So the government cannot say, I allow a political rally to be at this park because I agree with the message of that rally, but I disagree with the message of the other rally, and therefore I'm not going to give you a permit to have a demonstration because I don't agree with your message. So you cannot restrict expression based on content. Okay, you can restrict it based on what we call time, place, and manner. So the government can say, okay, you cannot have a rally at 5 p.m. because that's rush hour. Okay, that would be allowed. You also can say, we don't want it to be at this park, okay, because maybe it's too close to the counter demonstration. So you can regulate where the demonstration is going to take place without regard to its content, but you cannot deal with content issues. So, for example, it's very important to understand that, you know, you hear a lot about hate speech. Hate speech is not a legal term in the US, and the Supreme Court has repeatedly ruled that most of what would qualify as hate speech in Western Europe would be legally protected free speech in the First Amendment, okay? So if you say something like, oh, I hate such and such a group, and I want them to be exterminated, that may be illegal. And the government, let's say of Germany, can say you cannot do that, okay? You cannot, because they don't want to have a resurgence of the Nazi party in Germany. So they can ban hate speech in Germany under their constitution, but there is no such thing as a hate speech exception to the First Amendment of the United States Constitution, okay? And in a recent decision, 2017, so that's very recent, in a Supreme Court case, Mattel versus Tam, unanimous decision. We hardly have any more unanimous decision because we're so divided politically. Unanimous decision of the United States Supreme Court. There is no hate speech exception to the First Amendment. Okay, that's actually involving an Asian band, rock band that wanted to call themselves the Slant, okay, which is considered to be like hate speech. And the question was whether or not the trademark office would grant them that trademark. And the Supreme Court said, you have no right to ban anything based on your content, your view of the content. That's a unanimous decision. A couple of other things. You are also as an individual protected from having to say something that you don't want to say. So that's also part of the First Amendment. Not only is the federal government not allowed to ban your free speech, it cannot make you say certain things either, right? So for example, the federal government cannot make you recite the Pledge of Allegiance if under your free speech you don't want to say it, okay? The government cannot force anybody to salute the flag because that's making somebody say something. So it's not just that they can't stop you from talking, they also cannot make you say something that you don't want to say. Okay, so this is also a very complicated area. There are a few exceptions to the free speech, which is that the government is allowed to stop you from saying something if what you say constitutes what we call clear and present danger. So you cannot incite a riot if it is going to lead to an imminent danger, okay? So there has to be reasonable ground to believe that the danger is imminent. So it's a time frame issue. There has to be probability of serious danger before the government can suppress your speech. So in a very famous case called Brandenburg, there's a rally where the people who rallied there promoted violent overthrow of the government, right? So everybody who went to this rally said, we think the government should be overthrown. It's a terrible government. We hate this government, okay? And the Supreme Court said, you cannot punish abstract advocacy of force. So if I go to a rally and I say, I think it's a great idea to overthrow a government, okay, that's abstract. That's part of my free speech, okay? You have to show that by saying I want to overthrow the government, that it will lead in a very clear and present danger way to the overthrow. So you can have a view that I want to overthrow the government, but if it's abstract, it would still be, it would also be protected. Now, a couple of things, I've run out of time, so I want to, unfortunately, I only have 5 minutes left, but I want to bring up a couple of things. The 14th Amendment, which was passed after the Civil War, and it's really designed to protect Black Americans who were recently, at the time, had just been freed, okay? And after they were freed, the Southern states passed all kinds of laws to make sure that their lives were miserable. No drinking of the same fountain, separate schools, etc. Okay? The 14th Amendment has a provision which says that it prohibited certain practices like on the basis of race, okay? And for a very long time, the states, the Confederacy, had a long and pernicious history of segregation. And amazingly, the Supreme Court ruled that if you want to separate African Americans from white Caucasian Americans, in school, in restaurants, in trains, in bathrooms, in swimming pools, it's okay. It does not violate the Constitution as long as the separate facilities were equal, okay? So the separate states, so I mean, they're clearly not equal, but they were justified that they were equal. And all the way up until 1954, because of a decision called Plessy versus Ferguson, separate but equal was allowed under the US Constitution. In 1954, the NAACP, Legal Defense Fund, which is NAACP stands for National Association for the Advancement of Colored People, and it's mostly for, it was mostly African Americans who fought for this. They challenged separate but equal, and the Supreme Court under Brown versus Board of Education made that separate but equal unconstitutional. So I want you to understand, for example, that many Asian American kids before Brown versus Board of Education also attended segregated schools. So if you follow the history of civil rights in the US, all of the cases that appeared before the Supreme Court that were fought for by African Americans have benefited all of us tremendously. And I'm very grateful for the Black civil rights movement for forging this path, which has actually helped all minorities in this country, okay? So I hope that you will take some time and study the Black civil rights movement, because a lot of the things you have now, which we take for granted, would not have happened without all of the peaceful civil disobedience that were organized by groups that were led by people like Martin Luther King, okay? It's important to understand the history of this country as a minority and to understand how you fit into that as well. So just one more thing, I have 3 more minutes, and I wanna point out something with respect to immigration. There's been a lot of very racialized immigration history in the US, okay? And when you see a president issue an executive order banning the immigration of any group, you should ask yourself, just like any executive order, and not just executive order, congressional legislation that are banning immigration, go back to the 1800s, you understand that there was also a huge ban against the Chinese. So Congress enacted the only, I think it's the only immigration law that is against a particular nationality, and that's the Chinese. Okay, so the Chinese Exclusion Act was the first federal race-based restriction in immigration. And because immigration is very much kind of delegated by Congress to the president also has a lot of power in the immigration law area. So the Chinese Immigration Act basically said that the Chinese, even those who were in legally, if they had left the US and they were in China visiting their family, okay, the Scott Act of 1888 would deny them re-entry into the US, where they may have families already with children born in the US who are American citizens. Those Chinese that had left the US can no longer re-enter. And the Supreme Court in 1889, they had to decide whether or not the Chinese exclusion cases were constitutional. They said that yes, it was constitutional, because as an incident of sovereignty, Congress could defend America against an Oriental invasion. So Congress basically has a lot of power in the constitutional system to pass whatever immigration act that they want, because the immigrants are not citizens yet, right? And this is about a border measure. So even if the border measure has race tinge, this is one area that the courts have deferred to Congress, and they have not second-guessed Congress much. The only reason why we don't have the Chinese Exclusion Act anymore was because it was not because the Supreme Court declared that it's unconstitutional under the 14th Amendment. Okay? So this has never been tested in the Supreme Court. And the Supreme, what I meant is the Supreme Court has not declared this racial exclusion or racial bans to be unconstitutional. In fact, they held it to be constitutional, but the reason why the Chinese Exclusion Act is no longer in existence was because Congress took it upon itself to repeal the Chinese Exclusion Act in 1943. Now, you should ask yourself, why in 1943 did Congress decide to repeal the Chinese Exclusion Act, which had been in place since the 1880s? What do you think? Well, China became an ally of the US in World War II. And it looked horrible when the Chinese are fighting with the US, the Chinese being an ally, to have their Chinese ancestry in America being treated badly. So as a result, the Chinese Exclusion Act was repealed by the Magnuson Act in 1943. One more thing, and then I'm going to turn it over to Anlok. So one other issue regarding naturalization. So up until now, I've only talked about immigration. With naturalization, who can be naturalized? Okay, the first naturalization statute was passed in 1790, and it restricted naturalization to only free white immigrants. So if you enter the US as an immigrant and you're from Europe, and you're not indentured, okay, so you still have to be a free white person, you would be able to become a naturalized American citizen, but only if you're white. That was amended after Civil War to include African Americans, okay? So an African American would also be able to, quote, be naturalized even though they were born in this country. Now, the question is, in 1922, a Japanese person immigrated to the US and said, can I be naturalized as a white person? And the Supreme Court said, no, you're not white. The category only, and the Japanese said, well, I'm not Black and I'm not American Indian. And the Supreme Court said, no, white men, Caucasian, cannot be disturbed. A person from India said, well, you know, I'm actually Caucasian, even though I have darker skin. So I should be eligible for citizenship. In a case in 1923, the Supreme Court said that white meant Caucasian, and you have to look like a Northwestern European who were bone of their bone and flesh of their flesh. So that also excluded the Hindus, okay? One bright spot, 1898, the Supreme Court held that if you are born in the US, even if you're Chinese, so despite the Chinese Exclusion Act, if somehow you are, so as the Chinese Exclusion Act banned immigration from China. But if you are Chinese and you're born, you give birth to a Chinese kid in the US, then you would be granted American citizenship, okay? So that's pursuant to the 14th Amendment. So I wanna make sure the Chinese Exclusion Act was an immigration issue, and the Wong Kim Art case that granted American citizenship to the Chinese, that's pursuant to the 14th Amendment, okay? So that's a different issue than the legislation. Anyway, I hope that, you know, when you see bans on immigration based on race, again, ask yourself very carefully some of the issues, you know, look at those in the filter that I've presented to you and ask yourself, is it constitutional? Not whether you agree with it. That's very important because the US system is based on a rule of law with fidelity to the Constitution. It's not fidelity to any party or to any president, okay? Know your rights come from the Constitution. It's not from any party and it's not from any executive branch. That's it. So turn it over to Adlok, and then Dr. Quan will follow up, and we can then have a discussion afterward as well. Thank you for your time. I'm going to mute myself.
Thank you very much, Professor Lan Cao, on your discourse on the U.S. Constitution. Since we are at the Museum of the Republic of Vietnam, we would like to have a short discussion on of the Republic of Vietnam government and its establishment after Vietnam become independent from France through the First Republic and the subsequent Second Republic. I would like to ask Quan to start.
Okay, thank you, Anlok, for the introduction, and thank you, Chị Lan, for another very informative talk about the history of the U.S. constitutional law and reminding us of our privileges and our duties as a U.S. citizen. Can you hear me okay? And
we can hear
you well.
Okay, so my part is to do a more basic short introduction to the history of the Republic of Vietnam's government and to go over some of the important clauses of the two constitutions of the Republic of Vietnam. This talk is basically mostly for students. I am not an expert in constitutional law or comparative laws. I'm a physician by trade, but I am also an avid student in the history of the Vietnam War. And I'm a founding member of the Museum of the Republic of Vietnam here in Westminster, California. So my talk will be rather brief and more basic. Okay, so let me first start with the Geneva Conference on July 20th, 1954. Can we have the next slide, please? Yeah, which the Geneva Conference, July 20th, 1954, for you students out there, divided Vietnam at a 17 parallel into the Democratic Republic of Vietnam in the north and the socialist and the state of Vietnam in the south. The north was headed by Ho Chi Minh and the communists, and the state of Vietnam in the south was headed by Bảo Đại, his prime minister Nguyen, and the nationalists. There's an issue that I like to bring up when you study about history of Vietnam. For years, there have been a criticism about how South Vietnam did not allow for a free unified election as proposed by the Geneva Conference. The truth is that the conference was only signed by the Viet Minh Communists and the French. South Vietnam's government and the US never officially signed the conference. South Vietnam was reluctant. On one hand, they wanted to get it over so they can get rid of the French. But on the other hand, they did not think that France had the right to give away much of the land in the north to the communists. So this final declaration about a proposed unified election in 1956 was something that slipped in late during the conference, and it was not signed by any of the participants. South Vietnam never believed that a fair election with the international supervision could occur in the north, which at the time was a totalitarian communist state and had 1 million more in population. Next slide, please. After the Geneva, nearly 1 million North Vietnamese fled south in 1954 because they did not want to live under the communist rule. And many more would have followed if the Viet Minh had not stopped them with force. When the government of the state of Vietnam was formed, it was a very young, fledgling democracy with the aspiration to be like that of the US and many countries in the Western world. However, it was faced with a lot of internal problems. It had to eliminate the Binh Xuyen criminal syndicate around Saigon and Gia Leung, and it had to subdue two large religious sects of Hoa Hảo and Cao Dai, which had their own armies. Besides those, there were also thousands of communist cadre left by the North to later form the National Liberation Front of the Viet Cong, which was starting the insurrection in the South. Next slide, please. Nguyen became the president of the First Republic of Vietnam on October 23rd, 1955, after quelling all the rebels and winning a national referendum to replace Bảo Đại, who was the old emperor and later head of state. President Nguyen was credited for building the early infrastructures of South Vietnam, opening roads, opening schools, hospital, university, military academies, and for jumpstarting the economy with its mainly farming and light manufacturing industries. President Nguyen accomplished all of these tasks with the help of the U.S. Eisenhower administration. Next slide. The following year, on October 26, 1956, the first constitution of the Republic of Vietnam was drawn up by a group of French educated scholars and American advisors, and it was promulgated. Next slide. Its provision was to establish Vietnam as an independent, unified, and territorially indivisible state. Next slide. The executive, legislative, and judiciary have the responsibility to defend freedom, democracy, the republic government, and to keep public order. All citizens, without distinction to sex, are born with equal dignity, rights, and duties. Next slide. The Constitution of Vietnam strictly opposed all activities which directly or indirectly propagate or establish communism. This was an important declaration for both the First and the Second Republic. There's no tolerance of the communists who were trying to overthrow the Republic government. Next slide. The first Constitution recognized and guaranteed the rights to private property. The second Constitution later emphasized freedom of trade and competition, but without monopolizing the market. This is contrary to the socialist government of North Vietnam, which did not recognize private property and free trade until their late transformation to the market economy in the early 1990s. Next slide. The president and vice president were elected by universal and direct suffrage for 5 years and were eligible for re-election for 2 terms. Nguyen was the president for 2 terms and his vice president was Nguyen Van Thơ. Next slide. The First Republic only had 1 unicameral Congress with only 1 house in the National Assembly. Next slide. The First Republic did not have a Supreme Court. It had a constitutional court with rather limited power to decide on the legality of laws, orders, and the council, and some administrative regulations. Next slide. There was also a clause for the president to decree a temporary suspension of rights of freedom of movement, speech and press, assembly and association, and to meet the demands of the public security, order, and national defense. President Nguyen's First Republic government fell out of favor later and was accused of not sufficiently democratic, too oppressive with the Buddhist uprising, and not able to handle the communist Viet Cong insurrection. South Vietnam military leaders staged a coup on November 1st, 1963, under the approval of U.S. President Kennedy administration. President Nguyen and his advisor brother Nguyen were murdered to prevent a political comeback. Next slide. Oh, this slide is fine. After the military coup against President Nguyen, the Republic of Vietnam's government became unstable, went through several military junta, and one brief period of civilian government from 1964 to 1967. The Viet Cong rebels, at the meantime, gained more strength in countryside, and the U.S. eventually had to send in its massive military to help defend South Vietnam. Next slide, please. Nguyen Van Thiệu became the president of the Second Republic of Vietnam after a democratic election in 1967. His vice president was Nguyen Cao Kỳ. General Thiệu had risen in rank among the generals of the military junta to lead the government. President Thieu was credited for implementing land reforms for the farmers and for helping to build the Army of the Republic of Vietnam, so-called the RVN. He served terms until April 1975, when he resigned before the fall of Saigon. President Trần Văn Hương and then Dương Văn Minh briefly took over the last few days of the Republic. Next slide. The second Constitution of Republic of Vietnam was promulgated on April 1st, 1967. This constitution was more comprehensive and had more sharing of power among the branches. It had a few notable provisions that's worth mentioning here. The state recognized and guaranteed the basic right of citizen as stated. Next slide. Again, similar to the first constitution, the second constitution was adamant about opposing communism in every form and prohibited every activity designed to propagandize or carry out communism. Next slide. The state will respect and guarantee freedom of religious belief, and no religion will be recognized as a state religion. This was a response to the previous President Yim administration, which was accused of favoring Catholics over the Buddhists. Next slide. All military personnel elected to public office or serving in the central government must be demobilized. Those on active duty were not permitted to engage in political activity. This was an attempt to separate the military from the civilian government. Next slide. Our prime minister was appointed by the president for a member of his own government to help administer agency and to carry out national policy. Mr. Trần Thiện Kim was the prime minister of the Second Republic, and he resigned on April 1975. Mr. Vũ Văn Mẫu served briefly during the last few days of the Republic. Next slide. The Second Republic had a bicameral Congress with the lower house of representatives and the upper house of senators, pretty much similar to the US Congress. The Congress can vote on legislation, ratify treaties, determine declaration of war, control the government in carrying out national policy, and there are ways to introduce a bill and how to pass it. This will share power among the three branches. Next slide. The Supreme Court, which had the power to interpret the Constitution, decide on laws, dissolve political party which oppose the Republican regime, and decide on appeals from the lower court. Next slide. Another considered important clause was that the nation now recognized that different political parties have an essential role in a democratic system. The nation encouraged toward a two-party system, much like in the US right now. This was a response to the previous President Yim administration, which was accused of suppressing oppositional political parties. Next slide. The Republic of Vietnam ended on April 30th, 1975, after the communist takeover of Saigon. Afterward, 1 million soldiers, teachers, government officials, and workers were sent to concentration camp, re-education camp for many years. Since then, more than 2 million Vietnamese have fled the country to seek freedom abroad. Vietnam is presently a unitary Marxist-Leninist one-party socialist republic, which means that you can only vote for members of one political party, the Vietnamese Communist Party. Next slide. Well, this concludes my short introductory talk about the history of the Republic of Vietnam's government. I hope that you have a basic understanding that South Vietnam, despite its deficiencies and difficulties in time of a long war and facing enemies from within and abroad, the country did try to establish a democracy with a constitutional republic government similar to that many of the free world countries. And if you are interested in about the history of the Republic of Vietnam, which we will have many future lectures. So please keep an eye on our website and our Facebook. Thank you.
Thank you. Thank you very much, Professor Lan Cao and Nguyen for the presentation. Now we will move into the question and answer session. If anyone have any question, you can send them through the chat, or you can raise the hand icon and we will pick a few questions to answer. I have two questions here. And the question is, I believe for Professor Lan Cao, that's during the periods between 1954 and the fall of Saigon in 1975, the Republic of Vietnam was engaged in nation building. The government was newly established and a new constitution was adopted. It was challenging for the South Vietnamese government to implement all the provision in the newly adopted constitution because of the ongoing war and associated security needs. The US also experienced periods in history that are similar in that the country experienced civil war or unrest, and it was necessary to constrain certain provision in the Constitution. Professor Lan Cao, could you elaborate more on this period in US history and perhaps compare to South Vietnam during the Vietnam War? In what way are they different and in what ways are they similar? Please unmute yourself, Professor Lan Cao.
Okay, can you hear me now?
Yes.
Yeah. So I think it's very important to understand that in many countries, not just South Vietnam and not even the US, liberal democracy. Again, you know, I really want to make sure everybody understand the distinction between just democracy, which is just majoritarian rule, and liberal democracy, which is majority restricted, okay, in accordance with the Bill of Rights or some version of the Bill of Rights. These kinds of democracies are always tested, and it is a work in progress. Even the United States has undergone many periods in its existence where its democracy was not perfect. And I think that's very important to understand. So for example, just from, you know, from the very inception of the US birth, there was no real democracy because only white men who owned property could vote, okay? If you're white and you didn't own property, you would not have been able to vote. So how can that be a great democracy? Okay. As the country progressed, you have the 13th Amendment, you have 14th Amendment, which gave people, only Black men, the right to vote. So the women didn't even get the right to vote until the 19th Amendment. So this is without any period of war or insurrection. This is just the norm. So even the US went through a transition towards the kind of democracy that it promised in its own constitution. Throughout its history then, its democracy was also flawed. Now there was, as early as very early on after its ratification, 1789, the US Congress passed the Alien and Sedition Act of 1789, which restricted aliens, curtailed the press, etc. And you can say that, well, that's a very young country at the time because the country didn't come into existence until 1776, right? With the Declaration of Independence. So that's relatively young. I don't want to focus too much on that because you can say, well, that's only a few years after the Constitution was ratified. Let's talk about during the US Civil War, which I think is very similar to the situation of the war in Vietnam. President Lincoln issued an executive order. So we're back to executive order, which suspended what we call the writ of habeas corpus. The writ of habeas corpus is basically a right whereby if the government is going to arrest you, okay, they cannot just arrest you and just leave you in a prison without ever charging you with something, so that you have a chance to defend yourself before an impartial institution like a judge, right? So the writ of habeas corpus is basically a legal procedure that prevents the government from holding an individual indefinitely without showing cause, like, why am I holding you? Okay, so President Lincoln suspended unilaterally the writ of habeas corpus. And the Justice Supreme Court, you know, the Justice Taney of Maryland had to decide on this issue, and it was a very unclear issue, because what happened is that during the war, Lincoln faced many difficulties. The state of Washington, D.C. was located in slave territory, and the writ, the issue, the case is called ex parte merriment, okay? And it was actually involved the state of Maryland. So Maryland did not secede, but it was right next to Washington, D.C. And there were a lot of sympathy for the Southerners in Maryland. So Lincoln suspended the writ of habeas corpus between Washington, D.C. and Maryland and Philadelphia, and basically allowed the military to silence all dissenters, anybody who dissented against how the federal government was fighting the Civil War, and anybody who was a rebel, the government would be able to silence them. So you can tell that that's already a violation of the First Amendment, because that's it's not a content neutral suppression of speech. So under this order, military commanders could arrest and detain anybody who was deemed threatening to the military operation. Maryland, John Merriman was an individual who was a secessionist. He's from Maryland. He was arrested and held at Fort McHenry in Baltimore, and he appealed his release. He said, Lincoln does not have the power to suspend the writ of habeas corpus. The Supreme Court denounced Lincoln's interference with civil liberties and argued, interestingly, the Supreme Court did not say that the government does not have the right to suspend the writ. The Supreme Court said Lincoln, the president, did not have the power to suspend the writ of habeas corpus, and Congress would have the right to suspend the writ. Okay, so we're back now to, you know, the case of who has the power, even though the president was commander-in-chief. Interestingly, during the time of war, Lincoln decided, I'm not going to respond to Justice Taney's ruling. And he basically kind of like tried to put it in the Twilight Zone. And he decided that he could justify the suspension of the writ under Article 1, Section 9, which says that in case of rebellion or invasion of public safety. So you see that even in the US, which has had by that time 100 years of the Bill of Rights and democracy and all of that, the president unilaterally said we can hold anybody who is in favor of the rebels or who is critical of the Union, and we'll suspend the writ. We can hold you indefinitely. We don't have to take you to trial. We don't have to charge you with anything. Lincoln also implemented various wartime actions that are quite concerning, such as he seized the telegraph lines. He issued an order prohibiting the printing of any war news about military movements without his prior approval. He censored all journalistic dispatches, all US mail, all telegraphs were routinely censored as part of the war effort. And people were even arrested for wearing Confederate buttons. and singing Confederate songs. The government shut down the Chicago Times, which is a very powerful newspaper at the time, because the Chicago Times was excessively criticizing the Lincoln administration. The Lincoln presidency arrested editors. Papers were closed. Correspondents were prohibited from being at the field of battle because they were reporting things that the government did not want to report. A Democratic member of Congress from Ohio was arrested for making an anti-war political speech in his own home state. So, you know, I'm not saying that those things are right or wrong. Okay, so I'm not saying, see, it's great. I'm merely saying that at times of war, even a pretty well-formed democracy with all the sort of built-in constitutional separation of powers that I had just gone through with you also led to all kinds of suspension of the Constitution. So that's important to keep in mind. Keep in mind also, as recent as the World War II, the Japanese American citizens were interned in the US. And the Supreme Court held that that was constitutional. So we're talking about 1940, not the Civil War. Okay, the internment plan basically was a curfew, evacuation, and detention orders. And they only applied to Japanese Americans, not Germans, not Italians, which the US were also fighting. And there was a very famous case, Hirabashi v. US, basically addressed the issue of whether or not Japanese Americans should be subjected to a curfew that didn't include anybody else. Those all went up and were deemed to be constitutional because it's a time of war and the president has significant executive powers. And as it turned out, some of the evidence that the federal government under Roosevelt produced to the Supreme Court were inauthentic, and they had evidence to the contrary to show that there was no evidence that the Japanese Americans were plotting against. So again, always, you know, I think it's very important to question absolute power of any branch of government. When we hear about gridlock, we may be frustrated, but personally speaking, I'd rather have gridlock than absolute power.
May I add something to that?
Yeah, please.
Yeah. During the Vietnam War, much of the US aid, billions of dollars, was spent for the war effort. And the purpose was to build a large conventional army to face the very large communist army from the north. And not much was spent on building a strong Republic of Vietnam's government. So much of the powers was given to the military and not so much to the civilian government in time of war. It was then easy for the American anti-war media to portray South Vietnam as a military dictatorship and in order to undermine American support for the war. But South Vietnam only had 20 years to build a democracy, and the US had 200 years, and they were still facing problem with civil rights movement in the 1960s. So what these people, these anti-war people, have done is they have allowed for a more brutal, totalitarian communist government to eventually take over South Vietnam and enforce its ideology to suppress the people and take revenge on millions of soldiers and workers of the Republic of Vietnam.
Is it possible if I can add something as well in regards to the Japanese internment issue?
Yeah, please do.
Sure.
I mean, yeah,
Go ahead,
I
Andy.
would,
Go ahead.
I wouldn't say it was completely unfounded, though. I think there was an incident that happened shortly after Pearl Harbor where a Japanese American assisted a Japanese pilot in conducting a shootout on one of the remote Hawaiian Islands, and that kind of reached news to Roosevelt as well. And then before Pearl Harbor, there were actually Japanese spies that were recording the possible targets for Pearl Harbor as well that were in Hawaii at the time. So it wasn't completely unjustified.
Yes, yes, I have seen that movie of the Japanese pilot got shot down over one of the remote island, He's trying to instigate the rebellion against the government there. Hello?
Hello, yes, hi. There is another question that Annie Lake. You have a question to Professor Lan Cao. At what point does something qualify as a hate speech?
Well, hate speech is, there is no hate speech under the Constitution. So if you're talking about hate speech, there is no exception. So at no point is there a hate speech exception to the First Amendment, right? At no point. You can call anything hate speech. You can say that if you attack a person because of their race or ethnicity, but if you're silent about it, right? You're targeting somebody, but you don't call them a racial epithet when you attack them, it would be hard to show that that is, clearly that's a hate crime, but that's a conduct. If you're talking about speech, anything is hate speech if you say something derogatory about a certain group, but the government is not going to say that you're not allowed to say it. So at no point is hate speech a violation of the First Amendment. So here's an example. There's a very famous case called Skokie, S-K-O-K-I-E, if I remember correctly, because as I said, I'm not a constitutional law lawyer, neither am I a First Amendment lawyer, scholar, but I remember reading this case when I was in law school. I think it's called Skokie versus Illinois, if I'm correct. And it involved a case brought by the ACLU, the American Civil Liberties Union, which is out there fighting primarily for the First Amendment. And there was a permit being asked, a permit was requested by the Nazi Party. And they wanted to get a permit to, I guess, glorify the Nazis and to malign Jews. And they wanted the permit not anywhere in Illinois, but in Skokie in particular, because I think Skokie was a neighborhood that most of the Holocaust survivors had fled to after they survived Nazi Germany. And the question there was whether or not the government has to give them a permit, which would be very traumatic for the Holocaust survivors. And the ACLU fought that denial of the permit because they argued that, that quote, hate speech, not allowing it would be to allow the government to censor speech based on content, even if the content is hate. So there is no, to answer your question, there is no point at which hate speech is protected, is unprotected.
Thank you very much, Professor Lan Cao.
Can I speak? Professor Cao, I think that the question was more regarding the current situation in the US. And I think a lot of the, I guess, older and younger Asians are not feeling safe as far as moving around and having somebody maybe approach you and say something to you regarding your race. And so I think people are concerned and want to know if that is against the law, or what is against the law, and what can be done to stop it.
That issue is a local criminal issue, right? So if somebody is assaulting you, first of all, that is no longer speech. If somebody makes a threat against you, that's a violation because a threat is actually a tort or a crime. So we're not talking about the First Amendment anymore, right? Because again, if it's just a private person approaching you, it's not the government. That the First Amendment only protects you from what the government does. So if you're walking around in your neighborhood and somebody says something to you that is harassing, okay, that is not a First Amendment issue. It could be illegal because you're threatening somebody and you're putting them in fear of their life. You're being threatened, right? That is a separate criminal law issue. If on top of that, they say something that is racist against you while they are attacking you, that could be a hate crime. And there would be additional penalties, but it is no longer a speech issue, because if somebody is now threatening you or pushing you, then that is a local crime. And crimes are only local and state government. It's, in this case, there's no federal crime unless they are racist while they commit the crime, then the federal civil rights law could come into play for a hate crime, which you have federal laws against as well. Maybe state laws also prohibit hate crimes, in which case the person who is threatening you and pushing you would be subject to both federal and state government prosecution, because there's overlap. Because the federal government, there's also federal legislation against hate crime. I think that's correct. And again, I'm not a criminal defense lawyer. I actually only teach international trade. But I think this is just from my own following of this issue.
Thank you very much, Professor Lan Cao, for clarifying that. There's one question here. I think that it can go either to you and Quan. This is a question from Billy Lay. He asked that if the former Vietnamese government borrow or use part of the US Constitution within the system. If so, how so? So that's his question.
I don't know much about the Vietnamese government, but I do know that it was a civil law system, so it did not borrow the legal process from the common law, because the U.S. and countries that were colonized by Great Britain followed a common law system, and countries that, like Vietnam was a colony of France, they followed more like the Napoleonic Code and the civil law system. Although the fact that the president was elected made it more similar to the US system. It's not a parliamentary system with a prime minister the way, let's say, the British system is. So maybe it's a patchwork.
Okay.
Yeah, I'm not quite sure what the question is, but it's I agree, it is a patchwork of common laws of the English system, and they would try to patch some of the laws of the U.S. Constitution in there. So I don't think there's any problem with borrowing parts of the U.S. Constitution to use in the Vietnamese government.
Thank you both. The next question is from Sophie Nguyen. I believe that it's addressed to Professor Lan Cao. When you said that only white Caucasian individual could become citizen in the US in the past, when did the US permit immigrants from other countries with darker skin the opportunity to become a citizen?
I was in the middle of answering that. So basically what I was talking about, naturalization. Okay. So you can be naturalized and become a citizen, or you can be born in the US and become a citizen, right? By virtue of your having been born in the US. So the 14th Amendment says that if you're born or naturalized in the US, you are a citizen. And that was primarily designed to grant citizenship to African Americans who were born in the US as slaves, but because they were slaves, they couldn't become citizens, right? So the 14th Amendment dealt with issues of naturalization and birth. So the Wong Kim Ark case, which was decided in the 1800s. I can't, let me see if I have this in my notes about when it was decided. Yeah, 1898. That was the first case that recognized that the 14th Amendment, remember, as I said, the 14th Amendment was passed as an amendment in the context of the African-American experience and as slaves. So the 1898 case, Wong Kim Ark, that was the first time the Supreme Court recognized that the 14th Amendment, even though it had its roots in the Civil War and the civil rights of African Americans, that it granted citizenship to all persons born on American soil, even including the very unpopular Chinese. So my point when I was making the talk was that during that time period, you still had the Chinese Exclusion Act. Remember, the Chinese Exclusion Acts were passed by Congress, and they were not even repealed until 1943 by the Magnuson Act. And the Congress repealed it. It was not ruled to be unconstitutional by the Supreme Court. The Chinese Exclusion Act was constitutional until, Congress decided to repeal it in 1943 because China was an ally of the US. So while we still had the Chinese Exclusion Act, we also had the Wong Kim Ark case, which was decided in 1898. And the Wong Kim Ark case did not apply to immigration. The Chinese Exclusion Act applied to immigration. The Wong Kim Ark case simply said, if you're born in the US, you can be a US citizen, even if you're Chinese, right? So if for some reason you made it to the US, I guess even if you're illegally in the US, it doesn't say that, I'm just making the inference, you could be a US citizen. And this issue came up, if you recall, even very recently during the Harris, Vice President Harris, because actually one of my colleagues at Chapman Law School made the argument that, and it's a very minority-based argument. I don't think most scholars of the 14th Amendment would agree with him, but he was taking the minority view that even though Vice President Kamala Harris, at the time she was a candidate, even though she was born in the US, she was born to parents who were on student visas. And therefore, I don't know, I can't really defend the argument, okay? I'm just repeating it. Therefore, because they were on student visas, I can't even repeat the argument. Because they were on student visas and they gave birth to her, she couldn't be a citizen despite the language of the 14th Amendment, I guess. And that restrictive view of the 14th Amendment has been used to make the argument that if you're in the US illegally, not that her parents were in the US illegally because they were here on a student visa, but this argument became very popular because it's trying to say that if you come into the US illegally and you give birth to a child in the US, even though the child was born in the US, that child would not be a US citizen. So if you're born in the US, whether you're dark skinned or not, under the 14th Amendment, under Wong Kim Ark, you are an American citizen, despite the Chinese Exclusion Act. But that's only if you're born in the US.
I have a question, Professor Cao. You were talking about the encroachment of the executive power on the legislative power when it comes to declaration of war. Two of the incident that came up to mind were the Cooper Church Amendment, which limit U.S. troops involvement in Cambodia and Laos to destroy the Ho Chi Minh Trail, and later the War Power Act, which prohibit U.S. involvement in South Vietnam, and which pretty much ended all the aid, military aid later to South Vietnam and caused the fall of South Vietnam. So could you enlighten the student more about this kind of interaction between the president and Congress, fighting over the power to declare war?
Well, it's very clear under the Constitution that Congress is the branch that has the power to declare war. So there is no ambiguity in that. If you have a war and it qualifies as a war, Congress has to declare war. Congress sometimes has not been willing to declare war. So that's a political decision, okay, not a constitutional decision. So it could be that maybe the war is unpopular, or they're not sure whether or not they want to declare it explicitly for whatever reason, right? So they don't declare the war, but they do everything else instead of outright declaring the war. So for example, in the case of Vietnam, they passed the Gulf of Tonkin Resolution, which authorizes the president to take certain actions, maybe to defend US troops. And interestingly, during all that entire time period, while they did not declare war, they funded the war.
Right.
Okay, so there are many instances in the US structure where Congress, you could say, may be cowardly, right? But does not want to show its face, but doesn't want to take its constitutional position in a constitutional way, but wants to support the war. So if it never wanted to support the war, it could have easily just cut off funds, because the president does not control the purse. The Congress has the power to control the purse. So what the Congress and the president did in Vietnam is actually playing constitutional politics, right? It is creating on purpose a Twilight Zone so that it can continue something without actually formally doing something. And you can make the argument, and this is an argument for historians to make, whether or not fighting a war in the crevices, right? Not fully out there, but trying to find these different cracks in the constitutional system, is that a way to really fight a war? That you are not fighting really, but you are fighting in the shadow, and you never declared war, but later on you're claiming that you didn't declare war to weaken the president, right? So you're kind of playing politics even at home, but then why didn't you just cut everything off, right? So clearly the Congress did not want to cut everything off, but it doesn't have the guts really to fully declare war. And Johnson felt weak maybe, and he didn't want to push Congress to the declaration of war. So the war in Vietnam was fought in a very slippery terrain, and in many ways it put the ally of the US in a very weakened condition as well. And I think a lot of Vietnamese in South Vietnam never understood this, and many times basically trusted Johnson to do what he said he would do, or trusted Nixon to say what he would do. Because if you had understood the US constitutional system, you would have understood that actually Nixon didn't have that much power. And the power became even less when you have Watergate, right? So if you understand, I mean, Sun Tzu in The Art of War said you have to understand your enemy, but he didn't say you have to understand your ally as well. Because if you understood your ally, you would know, hey, you cannot put all of your eggs in the American basket, because the US was a very unreliable ally as well, because of its own constitutional structure, legitimate constitutional structure, and maybe because of politics within the US. And my understanding is that President Nguyen tried very often to find another ally besides the US. In fact, he had a secret dispatch with a Polish ambassador to try to have some kind of secret talk with Ho Chi Minh as well. And when the Americans found out about it, they were very, very upset. So, you know, there are a lot of things and intrigue going on. And it is very important to understand when you are an ally of the US to also understand that when you deal with the American president, you're not dealing with somebody with the full power for you to trust their words either.
Yes, yes. If President Thieu had realized that Nixon did not have all the power and a lot of the power lies on the Congress, then he would have trust President Nixon in signing that peace treaty in 1973 to let the U.S. Withdraw from South Vietnam, because he entrusted everything with President Nixon. So when after Nixon resigned after Watergate and the Congress cut off all the aid, we pretty much have nothing left.
But, you know, I want to add that even if he knew, I don't know whether he knew the constitutional system or not, or whether Nixon had the power to make any promises at all. But let's say even if he knew that, what could he do really? Because Nixon was saying to him, if you don't sign it, we'll sign it with North Vietnam separately. You know, there is a very famous American novel called A Separate Peace. He could have made a separate peace with the North, and he would have painted South Vietnam as being stubborn and pro-war and against peace. So in reality, you know, there's an African proverb. I don't know which country in Africa, but there's an African proverb that says the hand that receives a gift is always at the bottom. So if you are the person who depend on somebody to give you a gift, they're going to be on top of you. So if you know, well, Nixon promised we'll resume aid if North Vietnam breaches the Paris Agreement. Even if he knew that, what is he going to do? Say, no, I won't sign? Not much you can do. So which is why I think in many ways, it is wise not to have only one ally. Just like it's wise in life not to have just one friend.
Right.
Yeah.
That brings us to another point. We're having another lecture next month by George Writ, the author of Black April, and he's writing a new novel. It's called
No, not a novel. It's not a novel.
Oh, it's a it's a book based on his history book, based on his research about the history of the Second Republic, and it will bring up the point that you mentioned, that President Thieu was seeking for another ally toward the end of the Vietnam War, when the U.S. has abandoned Vietnam, and they would try to reach another solution, try to form another peace treaty with the Viet Cong and the North Vietnamese army through another government. And we will find out what that government is, as George Writ will let us know what he has found in his research in the history of the Second Republic.
Thank you very much, Professor Lan Cao and Quan, for the discussion on this big subject here. And as we see that in regard to Vietnam, much of the U.S. aid was for the war effort, building large conventional army instead of building a stronger RVN government. And we see that unfortunately for South Vietnam, it's become a military dictatorship in the eye of many people in the US and the world. So I think that we're running out of time for our discussion today. So thank you very much for attending today's talk, sponsored by the Museum of the Republic of Vietnam. We look forward to seeing you at a future presentation. Speaking of future presentation, Quan just mentioned that next month, George Writ, a former Army captain and an author of several books, several well-known books, I should say, on the Vietnam War, So please, the detailed information can be found on the museum Facebook page. Please come and register early for our next future presentation. Thank you very much, and have a good evening.
Thank you.
Thank you, everybody. Thank you, bác sĩ. Thank you, bác sĩ.
Thank you, Professor Lan Cao.
Bây giờ chị
Luật sư.
đợi hay sao?
I think if anybody wants to talk to you, I guess I will text you later.
What about người Việt?
Yeah, if any media wants to interview you, we will talk later. But let's end this meeting for everybody. Thank you, Anh Lộc.
Okay, bye bye.
Thank you.
Bye. Thank you.
Thank you, Anh Lộc.